This is part 2 in response to Sean's video about Ahmaud Arbery. The video I'm responding to is called Ahmaud Arbery Bombshell Case Update. Like my last video, I will still use any and all information before or on when Sean's second video was released, as it's well over a month since he made his second video. Sean's video can be broken down into 5 sections. The recap of his past video, Georgia's burglary statute, the motion to show Ahmaud's past actions, the usage of a disproportionate force, and Sean's personal opinion. I will, however, only be covering the recap, the motion, and the use of force, as Sean manages to get the statute right and his personal opinion is just that, an opinion. On to Sean's recap of his first video. He initially explains how the right was getting the travel distance wrong. However, he goes on next to say that he debunked how the left was misreading Georgia citizens' arrest statute. First of all, he makes no mention of this in his first video to how the left were interpreting the statute. However, what Sean does do in the video is misinterpret the statute.
So while the Georgia citizen's arrest statute says you are protected in your actions when you initiate a citizen's arrest when you personally witness a felony being committed, that doesn't mean that you can only initiate a citizen's arrest when you witness a felony being committed. This law is not a limitation on the citizen's arrest power of the people of Georgia. This law is a special protection in specific instances where Georgia does not want its citizens to not intervene out of fear of civil or criminal liability.
If it wasn't clear what Georgia's citizen's arrest statute was, a private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable or probable grounds of suspicion. He even gets it wrong in this video.
The next thing I debunked in this video was the way that Georgia's citizen arrest law was being misrepresented by the left-wing media. You see, they were talking about this 2010 statute, which talks about how you can go about, as a citizen, arresting people if you see them or have immediate knowledge thereof of them committing a felony.
To be clear, you can arrest an individual if they have done a crime in your immediate knowledge. It does not differentiate between felony or misdemeanor. Secondly, immediate knowledge doesn't just include witnessing. You can use any of your senses. And I'm not pulling this out of thin air. According to Merneigh v. State, it does not distinguish between misdemeanors and felony offenses. The term within his immediate knowledge enables a private citizen to use any of his senses to obtain knowledge that an offense is being committed. Sean then goes on to say,
knowledge thereof of them committing a felony. Now, what the left was doing with this 2010 law was ignoring all previous precedent that was set in Georgia for a concept that dates all the way back to English common law. And I thought this was really strange because I found specific cases around the citizen's arrest law that were involved with shoplifting cases.
However, in his first video, not only does he not mention any case precedent, but in both his videos, he fails to actually bring up common law interpretation for citizen's arrest. He'll give broad references to it, but he doesn't mention what it actually is. He'll keep bringing up how important it is, but not once does he state what it does. Sean, while he doesn't bring up case precedent in his previous video, he does bring up case in this one called Winn-Dixie Stores versus Nichols, and he does summarize the case correctly.
On top of that, I pulled up this Winn-Dixie case where we talked about what immediate knowledge thereof actually means. And in this case, this woman suspected somebody or had immediate knowledge thereof of somebody stealing their wallet inside a grocery store. And she tried to get the employees at Winn-Dixie to detain the suspect on her behalf. However, they did not do so, and the person ended up getting away. So she responded by suing Winn-Dixie, the company, for them not assisting her in detaining this person that robbed her of her wallet.
But then it goes directly downhill from there, as Sean states that while the McMichaels did not see him, they were told by another person.
People involved in this case did not see Arbery enter the building. However, they were told by another person that he was just in that building.
I don't know where he's getting that information, as he makes no references to it in this video, and his sources provide no explanation. Sean's statements are in complete contradiction with information that's been out for months now, that the McMichaels themselves are completely ignorant to Ahmaud entering the house that day, as according to the GBI,
was gunshot wound, manner was homicide.
I want to talk about statements of the defendants. There were statements of all 3 defendants that were given to a number of investigators in the case, including Glenn County Police Department.
That's correct.
First, focusing on Greg McMichael's statement, was there any body cam video obtained showing statements that he made to responding officers?
There was, yes, sir.
And just summarize any admissions or statements that he made to Glenn County police officers.
Greg McMichael pretty much relates on the body cam footage, and then later on, whenever he actually is interviewed on camera by the Glenn County Police Department, he makes admissions to seeing Mr. Arbery running down the roadway. His statement to the effect is he didn't know Mr. Arbery had stolen anything or not, but he had a gut feeling that Mr. Arbery may have been responsible for thefts that were in the neighborhood previously. And I think he actually says gut. His instinct told him that.
It's unclear where Sean is getting this information, that the McMichaels were told by another person that they saw Ahmaud committing a crime. According to the investigators, Greg's motivations were based on a hunch at the time. Sean goes on and then says,
And what this case determined was that immediate knowledge thereof is basically secondhand
I don't know
knowledge.
where he's getting this interpretation, as it's possibly the worst interpretation. Sean suggests that immediate knowledge is secondhand knowledge is completely ridiculous. I presume that this all stems from the presumption that immediate knowledge and sight are two different categories, based on this line.
Secondhand knowledge. If this woman would have saw this guy take her wallet in person, then she would have seen it. However, since she did not see this man go into her purse and steal her wallet, and she only had immediate knowledge thereof, she could not recruit additional people to help her with the citizen's arrest because she cannot transfer immediate knowledge thereof to another person. So essentially what the precedent in this Winn-Dixie case established was that in order to have immediate knowledge thereof, you can only be 1 degree of separation from the witness who saw the crime being committed themselves. Now, obviously, I'm putting this in layman's terms for you.
However, his own paragraph doesn't make the distinction between the two categories. The paragraph just explains that only the appellee could perform a citizen's arrest because she was the only person by the exercise of any of her senses had knowledge of the crime's commission. However, what we already know from Merneigh v. State, touch, sight, hearing, smell, and taste all fall under immediate knowledge. If she only saw them commit a crime, she would still have only immediate knowledge. The others would not be able to perform a citizen's arrest because they lacked immediate knowledge. Sean still leaves up why immediate knowledge is secondhand knowledge.
Essentially what the precedent in this Winn-Dixie case established was that in order to have immediate knowledge thereof, you can only be 1 degree of separation from the witness who saw the crime being committed themselves.
Sean never does explain where he gets this perception, because his own highlighted paragraph cannot be read into getting this interpretation. While Winn-Dixie does not make a suggestion about working on information from another person, the case Dinnan v. State explicitly makes clear that this is in fact the opposite. A private person may not act on hearsay or any information furnished to him by other persons. You can't be 1 degree of separation, as you cannot act on information told to you by other persons. The only person who can act upon immediate knowledge is that person.
Now, obviously, I'm putting this in layman's terms for you. If you want to read over the documents, the cases, and all that, they will be linked in the description, as always, under where it says sources.
The explanation that this is just layman's terms is an underhanded approach, as Sean's explanation is not consistent with either the text or the law. Moving past Winn-Dixie, at 4:29, Sean lies again about...
This is why, in my video, I talked about how the moment they pointed the gun at Ahmaud Arbery, they committed felony assault, or aggravated assault, I believe is the technical name for it.
In his first video, he makes no mention about pointing a gun. He only makes a statement about the McMichaels brandishing their firearms.
A felony, everybody who participated in that felony gets charged with their murder. So the whole issue is on whether or not him brandishing the shotgun outside of his car was in fact a felony assault. If that wasn't a felony assault, then there's no murder charge. That goes away. Remember,
it's been over a year since the McMichaels arrest came out. The one who's at fault for the aggravated assault charge is Travis. He's being charged for pointing and discharging his shotgun at Ahmaud. Gregory, on the other hand, isn't being charged for the cause, but as a party to the crime by aiding and abetting Travis. Furthermore, in the preliminary hearing that came out last June, the investigator stated what the reason was for the aggravated assault charge.
That you took, one was for aggravated assault. The basis, the factual basis of the aggravated assault, what are the specific facts that we discussed that you are saying this is the aggravated assault, that is the aggravated assault here of this count one?
My specific fact that I based the warrant on and I provided it would be that the aggravated assault occurred when Travis and Michael pointed a 12-gauge Remington 870 shotgun at Ahmaud Arbery.
Okay, when he pointed the firearm, and you described that as when he was standing next to his truck and Mr. Arbery was running towards him and he held the gun up like this when he was saying stop and get down?
That is one instance, and then Travis Michael indicates that he was pointing the shotgun at Ahmaud Arbery as he was approaching him at the front of the truck as well.
Okay, and that would be the basis of the aggravated assault.
That's
The
correct.
pointing of the firearm as he was running towards him and he was yelling stop, or when he came around the front of the truck at him and he pointed the gun at him after he came around the front of the truck at Travis.
That's correct. After Travis went around the front of the truck, yes, sir, that's
And
correct.
Mr. Arbery came around the front of the
That's
truck
correct.
at Travis. Travis points the gun. That's the aggravated assault at that moment.
And when Mr. Arbery was 30 to 40 yards away and Travis was pointing away.
If you're reporting on a case that's well over a year old, there shouldn't be a reason you shouldn't know who's being charged for what and for why. Moving on to Sean's discussion of the motion, the purpose of this is to lead to a justification of the use of deadly force by the McMichaels. However, similar to the common law, Sean doesn't examine whether or not this information will have any impact on the case, like whether it's admissible or not.
Any evidence whatsoever at the time that Arbery was actually engaging in a felony. Although we did have suspicions, and a lot of people had suspicions, the reality was a lot of people were just reading more into the case than we actually had knowledge of. However, a pattern of behavior that is established over multiple periods of time of Arbery not only breaking into places and burglarizing them, but of Arbery using being a runner or a jogger as a cover to do so, definitely lends credence to the idea that Arbery had intent to burglarize this location.
To note, Ahmaud has only been charged with one theft-related crime. He has been charged with burglary, he's only been charged with shoplifting. Examining whether this evidence is relevant in regards to this case deals with 4 statutes: 24-4-401, 24-4-402, 24-4-403, and 24-4-404, but we'll be mainly looking at 24-404. The statute does not allow evidence of wrongdoing to prove conformity, except for purposes of showing proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. So when Sean says,
However, a pattern of behavior that is established over multiple periods of time of Arbery not only breaking into places and burglarizing them, but of Arbery using being a runner or a jogger as a cover to do so, definitely lends credence to the idea that Arbery had intent to burglarize this location.
this is in alignment with proving conformity with an action. Showing propensity is inadmissible. Determining whether a past act is admissible, we can look at the case State v. Atkins, as it lays out a 3-pronged test. The other acts of evidence is relevant to an issue other than the defendant's character. Probative value is substantially outweighed by undue prejudice. There is sufficient proof that a jury could find a preponderance of the evidence that the defendant committed the acts. For the first prong, relevant to an issue, while Greg had witnessed Ahmaud enter Larry English's house on a prior occasion on video, by his own statement, he had believed Ahmaud had committed a criminal trespass on that occasion. The main goal of the prosecution is going to show that the McMichaels lack the ability to perform an arrest. The goal for the defense is that they're going to show Ahmaud had committed a felony and they had the ability to perform an arrest. The main issue for the defense is they lack the second part, as they had only believed Ahmaud had committed a misdemeanor, which only allows arrest to happen in the immediate, and they have no knowledge of Ahmaud's prior acts. For probative over prejudicial, we can use the case Bradshaw v. State. It establishes another 3 prongs: prosecutorial need, overall similarity, and temporal remoteness. For prosecutorial need, the motion makes no claim to how they are relevant. For similarity, the motion does not contain any acts of burglary. And for temporal remoteness, 2 of the acts have been committed 7 years ago, and the shoplifting charge had been committed 3 years ago. For the third prong, sufficient proof, the 3 additional times the motion had shown Ahmaud in the home, the defense had added the words, canvassing the interior property and valuables contained within. This assertion by the defendants that Ahmaud was casing the home is clearly speculative into the state of mind of Ahmaud. The McMichaels themselves only believed Ahmaud had committed a trespass at the time. As said before, Sean is going to use the motion to justify the use of excessive force on Ahmaud. His examination of the use of deadly force is akin to his examination of common law. He has zero idea what he's talking about.
Now, if this new information is introduced for the defense in this case, we now have reason to believe that the law that protects people who use deadly force against people who commit felonies that they either see or have immediate knowledge thereof would apply to the McMichaels, specifically Travis McMichael, but both of them because they're charged with felony murder.
I am confounded by his statement, as his examination would allow the usage of deadly force on people who have committed felonies. Or in other words, allow citizens to become executioners on the street. It's funny how he doesn't actually say what the law is. It's probably because that law doesn't exist. If it wasn't clear to you already, you're not allowed to do this. And as proof, according to Prayor v. State, for a citizen's arrest to be valid, the citizen must use no more force than is reasonable. Also, deadly force in effecting an arrest is limited to self-defense, or in a situation which is necessary to prevent a forcible felony. I don't know where he's getting the use of deadly force, as once again, he doesn't cite what he's referencing. This video is clearly a thinly disguised attack upon Ahmaud. If you only watched Sean's 2 videos on this, you wouldn't even be aware that there's a third guy named William Bryant, or that they've been indicted with several additional crimes, or at least understand like what happened that day and who's being charged for what. This shines a very negative light on the rest of his other videos, since if Sean missed basic information or lacked reading comprehension in this video, his other videos might have the same very issues.